This case I selected for my subscribers' viewing as this perv was in court in a jury trial for the charge of aggravated assault of a child, and it must have been going pear-shaped for him as he decides to plead no contest to the charges. The thing is, if he was found guilty, he would have been open to 99 years inside, which is the better place for him. I have no pity on the sickos in society. If anyone does, then this is definitely not the channel for you. Welcome to Off the Record.
The state of Texas versus Richard Lee Anderson. You are Mr. Anderson.
Yes.
The defendant, Ms. The defendant waive a formal reading of the indictment and the arraignment here. Can we proceed in summary?
Yes, sure.
And this is a trial that we have been moving forward on since Monday, and the parties have reached an agreement to dispose of this case outside a jury verdict. And again, the defendant waives a formal reading of this indictment. We're only going on paragraph 1.
That's correct.
And also arraignment is waived as well.
Yes, sure.
In summary, Mr. Anderson, this indictment alleges that on or about October 2nd, 2018, in Jefferson County, Texas, you committed the first-degree felony of aggravated sexual assault of a child younger than 14 years of age. Do you understand what you were charged with? You have to speak out so she can hear you, sir. Thanks.
Yes, sir.
If convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. An agreement's been reached between the parties. You would be pleading guilty and found
no contest.
I'm sorry. Stand by. All right, you would be pleading no contest.
Please.
Pleading no contest does not absolve you of being responsible and found guilty. Do you understand? It is up to the state to then present evidence. You don't have to plead guilty. You can plead no contest, but then it's up to them to present additional evidence to support your plea of no contest. And it's their obligation to meet the threshold for the court to find you guilty beyond a reasonable doubt. Do you understand? The plea of no contest does it is not a plea of guilty, but it is an understanding that you are being neutral on this. You are withdrawing your plea of not guilty, and we are moving forward based upon an agreement that's been reached by the parties. And that's the way it moves in this court. Sometimes people plead no contest. The state still has the obligation to present evidence. An agreement's been reached where you would be sentenced to 10 years in prison. You would be given credit for all time you have served, and that is the law. Is that your understanding of the agreement?
Yes, sir.
And then the state would not be prosecuting you for paragraphs 2 and 3, which would, if found true beyond a reasonable doubt, which would subject you to being habitual offender status, and then the punishment range would be no less than 25 to life in prison. Do you understand?
Yes,
sir. Under Article 27.02 of the Texas Code of Criminal Procedure, you must understand, sir, that a plea of no contest has the same legal effect as that of a plea of guilty, except that such plea of no contest cannot be used against you as an admission in any civil suit based upon or growing out of the act upon which the criminal prosecution is based. Do you understand how that applies? I now find you guilty beyond a reasonable doubt of this first-degree felony of aggravated assault of a child. I am following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. Now, there is sex offender registration.
It's been sent to you, Judge, on the
and
tablet.
Understand what has happened today, sir.
yes, sir.
All right. Anything else? We're not going to have any other proceedings.
No, Your Honor.
That sometimes occur in this type of matter. Okay. Then, anything else to add from the defense?
No.
All right, then the defendant is taken into custody. What will happen is we'll bring the jury in, tell them what has occurred and release them. All right, thank you.
And there he goes, off to go, hide in his cell, hoping that the other prisoners don't find out what he's in for, praying to whatever God he believes in that they don't, which is one of the reasons why I publish these cases. So the chances of someone seeing it and pointing out Richard Anderson the sicko is just a little bit higher. And what makes it just a little bit higher again is that instead of no one finding out, I pray to my gods that he does. And the thing about my God is that he is only full of love. And why would my God loving be a bad thing for Mr. Anderson here? Well, it's because my God loves to hate.
Warren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Israel Crane. Mr. Crane, state your name for the record.
Israel Crane.
Thank you. Your Honor, today is the date and time set for the probable cause conference. We are respectfully requesting that this matter be set for preliminary examination.
Discovery is all complete.
The best of our knowledge, Your Honor.
All right. People would have their witnesses available the 25th. Preliminary examination in person, June 25th, 2024, 9 a.m. That is before Judge Washington.
I do just have one thing I would like to address with the court.
Yes.
So Mr. Crane was in Michigan because he requested to be supervised while being out for his conviction for armed robbery and FA out of Virginia. Agent Bennett, who I believe is supervising his release here in Michigan, notified our office this morning that he believes that the defendant is having contact with the victim through his mother. I do want to note that I don't see I was not able to find any jail calls to the victim directly from Mr. Crane, but I am concerned based off of the need that Agent Bennett felt the need to notify us of this. I have not had an opportunity to have a discussion with Agent Bennett with regard to this allegation or what the basis for it is, but I am concerned. I have not had an agent feel the need to contact our office to notify me of indirect contact on an case previous.
Okay, but are there then phone calls that would even remotely substantiate that, like phone calls to his mother?
Yes.
But the content of those particular phone calls, we don't know.
I have not had the opportunity to listen to them yet.
Mr. Brown, I'm not sure what they're asking.
I think they're asking for his phone privileges to be revoked, but
they haven't said that he's had any contact. They haven't shown that he's directed anyone to do anything. We don't even know the extent of his mother's relationship with the complaining witness in this case. Without those facts, they're not asking for anything. They're just putting that out there.
Here's what I'll do. Is somebody going to be able to listen to those calls to indicate? I mean, it's one thing if he's contacting his mother and his mother is then reaching out in some way, whatever, as opposed to him attempting to try to send messages through his mother. There's going to be a difference. So I'm reluctant to do anything until such time as there's some indication that that's what's happening in terms of a third party contact. So maybe if you get a statement from the officers to how they know that, what information has come to them, get that to Mr. Brown and to the court. I may change that decision so that you're aware, Mr. Brown, where if I look at it and it appears to me that that's the case, then I may revoke his privileges, and you can certainly have a hearing before Judge Washington or this court regarding that. Okay. So I think that's probably the best way at this juncture to handle.
And for you, my subscribers that are watching, I have placed upon the screen now a playlist where I release upcoming episodes often, so please save it to your favorites and don't tell the others, as this is for you to say thank you. See you next time.